This is the ruling of the court made under the provisions of Article 23, 6AC, and 28, 3A of the Constitution, Section 14 of the Trial on Indictments Act, Cap 23, and the Constitution Bail Guidelines for Courts of Judicature, Practice Directions 2022. The applicant seeks orders of court releasing her on bail pending her trial. The application was brought by way of notice of motion, supported by the applicant's affidavit sworn on the 20th day of April 2023. The applicant, who is a member of parliament representing Bududa district and a minister of state for Karamoja affairs, is charged with dealing with suspect property contrary to section 21A1 of the Anti-Corruption Act 209 as amended. It is alleged that between the months of June and July 2022, at the office of the Prime Minister's stores in Namamve and in Kola Cell, Buluwanyi Parish, Mukono Municipality in Mukono District, she dealt with government property to which 2,000 pre-painted iron sheets of gauge 28 marked office of the Prime Minister by receiving and holding the said iron sheets, which she had reason to believe were acquired as a result of the loss of public property. She appeared before the Magistrates Court at the ACD on the 19th of April 2023, was committed to the High Court for trial, and she has been on remand since then, hence this application. When the application came up for hearing yesterday, the 3rd of May 2023, counsel for the applicant went through the grounds in the notice of motion and the supporting affidavit and submitted that the offense with which the applicant is charged is bailable, and this court has the discretion to grant the applicant bail, even as it is the applicant's fundamental right to apply for bail before this court. He submitted that the applicant has a fixed place of abode within the jurisdiction of the court and at all material times has been a law-abiding citizen, that she has been voluntarily reporting to police CID headquarters at Kibuli whenever called upon to appear, including the 18th of April 2023, when she was arrested and detained when she went voluntarily. That there are no other known pending criminal charges against the applicant. She has never been charged or arrested before. That the inquiries in the matter are complete, and as such, there is no likelihood of the applicant interfering with the prosecution witnesses or the investigations, and that the applicant has a young and dependent family and will not abscond if granted bail. It was further submitted that the applicant is a known patient of severe venous insufficiency, which is a very delicate and life-threatening disease requiring specialized medical attention, which the prison facilities do not have. Lastly, that the applicant has sound and substantial sureties who understand their obligation and will play their role in securing her compliance with any bail terms that the court may wish to impose. Accordingly, 3 sureties were presented to court for consideration. I will revert to the details of the sureties later in this ruling. A prayer for the release of the applicant on bail was then made. The application was opposed on grounds contained in the affidavit in reply to the motion, deponed by Detective ASP Ayebari Emmanuel Benon of CID headquarters. They are as follows. The applicant is a flight risk and has previously refused or declined to answer police summons. She abandoned her home, switched off all her phones in a bid to evade arrest. That this necessitated a public announcement by the police spokesperson who declared her a wanted person. And it was submitted that this conduct of the applicant has demonstrated in the averments in the affidavit prove that she is very likely to abscond when released on bail. It was also submitted that 2 of the sureties presented had not demonstrated their capacity to compel the applicant to appear in court when required or to meet the terms of the bond that would be set by the court as required under the Anti-Corruption Division Case Management Rules of 2021. Lastly, that the ill health of the applicant had not been properly proved as required by the law. Counsel for the respondent prayed, therefore, that bail be denied on the above grounds and the hearing of the case be prioritized as investigations are complete and hearing dates have already been fixed. In a brief rejoinder, it was submitted that the applicant had voluntarily reported to police upon learning that she was required, that the grounds raised by the respondent's counsel are based on suspicion and hearsay, and that the court has the liberty to release the applicant on bail even if there is only one substantial surety and set suitable conditions. Counsel reiterated his prayers that court find surety substantial and be pleased to grant the bail application. I have listened to the submissions of both counsel. I have perused the affidavits for and against this application. I have also perused the annexures and the documents presented before this court. I wish to state that the purpose of bail is not to free an accused person from any charges that he or she may be facing, but rather to allow a person to stand trial without necessarily being detained in custody during that time. Such a release would also accord the accused the unfettered freedom to prepare for their defense. The Constitution of Uganda guarantees the right to apply for bail in Article 23, 6A. And this right stems from the presumption of innocence, which is enshrined in Article 28, 3A of the same Constitution. The essence and the true meaning of the presumption of innocence as regards bail is that an accused person need not suffer incarceration unreasonably as he or she is not yet a convict. It is straight law that the court has the discretion whether to grant or not grant bail, but that this discretion ought to be exercised judiciously. This exercise requires a value judgment by the court on whether, in the circumstances of a given case and considering all the factors laid before the court, the applicant would be likely to return for trial if released on bail. The overarching consideration is whether a release on bail would serve the interests of justice, and the rights of the individual to freedom have to be carefully balanced against the interests of the community in addressing crime and being protected from it. Consequently, therefore, courts should lean in favor of and not against the liberty of the accused as long as the interests of justice will not be prejudiced. I have quoted the decisions, I will not read them out. The main considerations for grant of bail in the High Court are set out in Section 15.4 of the Trial on Indictments Act, and these include whether the applicant has a fixed place of abode within the jurisdiction of the court or is ordinarily resident outside Uganda. Section 15.4a of the TIA, whether the sureties are sound within the meaning of Section 15.4b, whether the accused has on a previous occasion when released on bail failed to comply with terms or conditions of the same, or whether there are other pending charges against the accused persons. Other factors to be considered are set out in the Constitution Bail Guidelines for Courts of Judicature Practice Directions 2022. They include the gravity and the nature of the offense, the antecedents of the applicant, the likelihood of interference with witnesses, and the stage of the proceedings, amongst others. It is not in contention in this application that the applicant has a fixed place of abode at Nantabulirwa Village, Seta Parish, Goma Division, Mukono Municipality, Mukono District, which is within the jurisdiction of this court, where she resides with her family. It is also not in contention that the offense with which she is charged is bailable and that she has the right to apply for bail before this court. Furthermore, the respondent did not contest the applicant's averments that she has a young family and looks after her elderly parents who depend on her for a living, and that she has no previous criminal record or other pending charges. Lastly, I observe that the case against the applicant has already been fixed for hearing, and therefore there is no likelihood of a delay in disposing of the matter at trial. I will therefore analyze and concentrate on the issues that are in contention in this application, and these are whether the applicant suffers from ill health that requires her release on bail, whether from the antecedents of the applicant she is likely to take flight if released on bail, and lastly, whether she has presented substantial sureties before this court to support her application. I will start with the ill health of the applicant. In paragraph 17 of the affidavit in support of the application, the applicant avers that she is sickly, having been diagnosed with severe venous insufficiency, which is a very delicate and life-threatening condition that can lead to sudden blood clot formation, which condition requires specialized medical attention outside of prison. To support this, Annexure D to the affidavit, a medical report made by ASP Dr. Muhwezi Julius of the Directorate of Police Health Services, dated 18th April 2023, was tendered in evidence. A consent to the examination by the applicant, witnessed by Detective Inspector of Police Alupo Auna Grace and duly signed on the same date, was also attached and provided to the court for consideration. From the report on physical examination, she was found to be in a fair general condition with mild anxiety. Her blood pressure was normal. There was obvious swelling involving the entire left foot and the lower 2/3 of her leg, with obvious depression created upon pressing, categorized as grade 2 or edema. She did not present difficulty in breathing. She had no cough, no chest pain or other external injuries. He reviewed her medical documents, which confirmed she is a known patient of severe venous insufficiency, a diagnosis made by a Dr. Kawoya, a radiologist. A copy of the radiologist's report was scanned onto his report. It shows mild, moderate to severe venous insufficiency on various points on her thigh and along the leg. She reported, in consistency with the condition, a history of fainting following blood clot formation in her lungs, which was resolved, and she's on medication to minimize blood clot formation. The author provides the significance of his findings as follows, and I quote, "Such a patient is a candidate who can develop breathing complications anytime and would need emergency intervention." End of quote. He prescribed the manner in which the patient should be handled while in police detention at Kira Road Police Station. Counsel for the respondent has objected to the report and asked this court not to attach any weight to it on the basis, one, that the technical expertise and experience of the author is questionable, that it was unclear how he came to examine the applicant. He also questioned how the applicant came to be in possession of the report, which is in fact an internal memo between the author and the CID officer of Kira Road Police Station. Lastly, he submitted that the findings of the doctor are not reliable, as he did not do any examination of the patient and instead relied on reports authored by other medical professionals. I have carefully considered these objections. I find no reason to doubt the fact that the applicant was examined, indeed, while in detention at Kira Road Police Station by a Dr. Julius Muhwezi, a police doctor, on 18th of April 2023, in the presence of a female police officer. There is uncontroverted proof to that effect. I note that the respondent does not deny the existence of such an officer in the police force, nor that he is a medical doctor, or nor that he is a medical doctor as he asserts in his report. And even in the absence of medical history or his qualifications and experience, the court can safely conclude that the person, Dr. Julius Muhwezi, who examined the applicant, is a qualified medical doctor. I therefore see no reason to reject his report, and I will proceed to analyze his findings in as far as reaching a decision in this matter is concerned. In his report, he states that the Directorate of Police Health Services, where he works as a medical officer, is charged with the duty of offering health care services to police, staff, their families, and suspects while in police custody. He thus booked himself in to assess the applicant's health issues and make sure she accesses the necessary medical support while with them. Review of a patient's medical history is, in my view, always a necessary factor when considering the health of a person. And I see no reason as to why he should have excluded them or not relied on them. I also find no malafide in his decision to examine the minister upon learning that she was in detention at Kira Road Police Station. I'm of the view that the applicant, through her averments in the affidavit and through the annexure report of the medical doctor at Kira Road Police Station, sufficiently proves that she is medically ill and under treatment. And under treatment to avoid reoccurrence of a clot. I'm mindful that in Section 15.3a of the Trial on Indictments Act, proof of exceptional circumstances of grave illness certified by a medical officer of the prison or other institution or place where the accused is detained as being incapable of adequate medical treatment while the accused is in custody is required. I note that we have no report tendered by any other medical officer that controverts what has been tendered by the applicant, including the medical officer of the prison where the applicant is currently detained. I have considered the report of the police doctor made while the applicant was in detention at Kira Road Police Station. In my view, it sufficiently shows that the patient suffers from a condition that is delicate and can be life-threatening and reoccurring, thus requiring keen medical attention. The fact that she is reported to be capable of developing breathing complications requiring emergency intervention, in my view, satisfies the requirements of grave illness within the meaning of Section 15.3a of the TIA. But it should be noted that even in the absence of a medical report within the meaning of the section from a place of detention, the court still deserves the right to grant bail or not. I now move to whether the applicant has sound sureties within the jurisdiction of the court to undertake that she shall comply with the conditions of her bail. In determining the suitability of a surety, the court is enjoined to consider the age of the surety, their work and residence, their character and antecedents, their relationship with the applicant, and any other factors that the court may deem fit. Rule 14 of the Constitutional Bail Guidelines for Courts of Judicature Practice Directions refer. Further, Rule 7 of the High Court Anti-Corruption Division Case Management Rules 2021 provide that the court shall, before considering any person to stand as surety for an accused person, determine that the person has the capacity to A, influence and compel the accused person to attend trial, and B, to meet the terms of the bond. 3 sureties were presented to court. The first surety was Nangoli Edward, MP for Elgon North. His national ID, work ID, and letter of introduction from his area chairperson were tendered in court. He is the chairperson of the Bugisu Parliamentary Group, where the applicant is said to be a member. He was also said to be a long-term friend of the applicant even before their election to Parliament. The second surety was Nandalam Nathan Mafavi, MP for Budadiri County West, Sironko, and chairperson of Bugisu Cooperative Union, former leader of opposition. His work ID, national ID, passport, financial card, and bank statements were deposited with the court. A letter of introduction from the chairperson of the area where he resides was also submitted to court, and 4 land titles were furnished as proof of his financial capacity to pay bond terms and as extra security. The last surety was Amoti Milton Apollo Wangui, LC5 chairman of Bududa district. A letter of introduction confirming his residence was tendered along with the national ID and work ID. He was said to be an uncle to the applicant. The state did not controvert the fact that the applicant's sureties all have places of residence within the jurisdiction of the court. I will therefore not dwell on this issue. They also did not contest the suitability of surety number 2, Nandala Mafabi. They, however, opposed the other 2 sureties on grounds that their capacity to compel the applicant had not been demonstrated. It was said that it was not enough that there are people who hold high offices, but their influence over the applicant needs to be demonstrated. It was also submitted they had not demonstrated capacity to pay the bond terms as required under Rule 7 of the ACD case management rules. I have considered the fact that the two sureties in question are said to be long-term friend and an uncle to the applicant. They are mature adults. They hold positions of responsibility in the community, one as a member of parliament and another as LC5 chairperson of Bududa district. Additionally, the first surety is the chairperson of the parliamentary group to which the applicant belongs. I am satisfied that by the nature of the relationship of these two sureties with the applicant and the positions that they hold, they have the capacity to influence the applicant and compel her attendance. Also at Nandutu, registered in the applicant's names, shall be deposited with the Deputy Registrar of this court as extra security. The applicant's passport is to be deposited with the court. 5, the applicant is banned from traveling outside the jurisdiction of the country without the leave of court until the disposition of the case. 6, additional security of duplicate title for land comprised in Chadondo Block 224, Plot 844, land at Namugongo in the name of second surety shall be deposited with the Deputy Registrar as additional security. The applicant will continue to answer on the dates that have been assigned to her in the main case. That is the ruling of this court.
No, katika musau. That's why Kawan.
Most. Let the microphone yangu.